Hello and welcome. This is Legal Focus on TVC News. Sexual harassment in the workplace is rampant in Nigeria, and statistics say that the legal profession isn't immune to this unhealthy practice. But now, lawyers have come up with solutions. Plus, an exclusive interview with Senior Advocate of Nigeria, Moyosore Onigbanjo. And later, we'll bring you sound legal advice on search of persons by law enforcement officers. Welcome to the program. Employees in Nigeria suffer sexual harassment daily, but not much has been seen to be done to stop the trend or get justice for the victims, who are mostly women.
Studies have revealed that about 63 to 68% of victims of sexual harassment are usually female. But that's not to say that the male folks are not also sexually harassed.
Despite the existence of the Nigeria labor law since 1971, there is no express provision on sexual harassment. The National Industrial Court of Nigeria once considered such cases under the Fundamental Human Rights Enforcement Procedure Rules of 2009. The first time was in 2013 when Justice Osato Obaseki Osage awarded a lady 39.6 million naira against her former employer, Microsoft Nigeria Limited, the parent company, Microsoft Corporation, as well as her harasser, in damages for the termination of her employment after refusing his sexual advances. Nigeria's 1999 constitution, amended in 2010, then elevated the industrial court to the status of a superior court with expanded jurisdiction and powers. This enabled the court to make provisions in its 2017 rules for sexual harassment claims. Order 14 of the rules defines the term broadly as being physical, verbal or non-verbal, and the fourth, where an employer, supervisor, member of management or co-employee seek to influence employment, promotion, discipline or salary increment in exchange for sexual favors. 2 years after it rocked Hollywood and spread widely across the world, the hashtag #MeToo movement against sexual harassment and sexual abuse has also spread to the legal community in Nigeria. At the annual conference of the Section of Business Law, an arm of the Nigeria Bar Association, victims are speaking out at this breakout session.
Sexual harassment in the workplace is real. I have been a victim before, countless times in my previous employment, and it's not a good place to be in. But I feel owning up to it, knowing the fact that, okay, this has happened, I can beat the system, and also protecting the ones coming after you is what is the system I used to conquer it.
I went to apply for a job, and then the man just did what he did, and for me it was a very traumatizing experience. It took my support system to help me get through it.
The International Bar Association's 2019 report on bullying and sexual harassment in the legal profession says 1 in 3 female lawyers and 1 in 14 male counterparts have been sexually harassed at work. The 130-page landmark report titled Us Too collected data from nearly 7,000 surveyed legal professionals in 135 countries. And about 75% of those cases go unreported. About 65% of affected practitioners have also left or considered leaving their workplace as a result. Nigeria is among the 7 nations with the highest prevalence.
Now, as a committee, we are looking at various things. We're going to try and sponsor a bill on sexual harassment. We're going to try to invoke the powers of the minister under Section 88 of the Labour Act to create regulations and guidelines on sexual harassment. This, in the next year or so, we would achieve. If not the legislation, but the regulations and the guidelines.
Why should I still have to go to court of appeal, then go to Supreme Court just because I was sexually harassed at work, and this person is out there flourishing? I am spending money on a lawyer, I am spending my time pursuing a case that they might come and say, oh, I didn't even have enough evidence.
We do recognize that it's happening among the legal community. We do recognize that it's happening in the law firms, it's happening in the judiciary, it's happening where lawyers work, and we're wondering why, because lawyers should know better, because they know what constitutes, they know that that's illegal, that amounts to a breach of the law, even though that there's really no written law in Nigeria. So these are the things we need to address. We need to toe the line of the IBA. Maybe the NBA will also conduct a survey and find ways to protect its own.
International labor standards have now been upgraded as delegates at the Centenary International Labour Conference in Geneva adopted the 2019 Violence and Harassment Convention number 190 and the accompanying recommendation number 206. Persons protected are workers irrespective of their contractual status, persons in training, workers whose employment have been terminated, volunteers, job seekers, and even employers. The convention, which is a legally binding international instrument, will enter into force 12 months after 2 member states have ratified it, but parties are reminded of their duty to promote a general environment of zero tolerance. Lawyers in Nigeria are now determined to hasten the process that will put these protections into practice so that a safer working environment for women and men can be guaranteed.
In our judicial system, from practice, it is very, very difficult to prove rape in court because the conditions stated by law for a rape case to succeed in court are very, very rigid and stringent. So it's more than just shouting, "I was raped." You must show the bruises where the male was trying to force his way into you. Then a specimen of his semen must be found in the vagina of the girl, which semen will also correspond with the semen with the alleged rapee. Most rape cases, if it happens, the best thing is to make a report immediately, because there will be doctor's report, a report to the police. Those are the evidence one will gather to prosecute such a matter, not staying low for a week, 2 weeks, not to talk about years.
The offense of rape generally is actionable, but it is left for the prosecution to prove his case beyond reasonable doubt for him to get justice. The police, the courts, and the prison authorities have a role to play.
There is no limitation of time as to institution of criminal proceedings as to rape cases. Now, the major ingredient in proving the guilt of a person alleged of rape is the absence of consent by the person who alleges of that offense. Most importantly, is the fact that we need to challenge victims of rape to step out of that dark secret place of self-stigmatization and make themselves available to the police. We need to go through that education wherein we educate ourselves to the point that people who are alleged of rape or people who are victims of rape have the right to be heard, the right not to be stigmatized, the right to even be given justice in the first instance. So going forward, I believe that it's on the principles of that the court itself can go forward in the course of trial, establish the question of absence of consent, and on that basis alleged perpetrators of rape cases can be convicted. And we want to see in this court an open trial of all the allegations we have seen circulating in the social media and all of that. Those complainants should go to the police station and make complaints. We want to see those matters taken before the court. We want to see those alleged perpetrators of crime being arraigned in court, be they religious leaders, be they political leaders, or whatever they are called, in open court, tried accordingly and sentenced accordingly.
You're watching Legal Focus on TVC News, and now you're on to The Advocate. This segment talks or takes us into the world of legal luminaries of our time. The advocate this week is Moyosori Onigbanjo, a senior advocate of Nigeria. Welcome, sir, to the program today. Tell us about your childhood years and the point when you knew you were going to be a renowned lawyer.
Well, I come from a middle-class family, grew up in Surulere, Lagos. I attended Sunnyfields Primary School. That school, by the way, we have, I think, 5 senior advocates. I doubt if there's any primary school that can match us.
As at now?
As at now, yes, and more to come.
Indeed.
Yes,
Amen.
and I attended St. Finbar's College, then I read law. Funny enough, my university degree says I graduated from Obafemi Awolowo University, but I never actually stepped into Obafemi Awolowo University. I was admitted into University of Ilorin to read law. After my final exams, that was in 1998, the NUC, National Universities Commission, cancelled our law program, and as such, we were the right to award LLB degrees was withdrawn. But fortunately for us, we had a professor from Guyana, Professor James, who was one of the pioneer lecturers in the then University of Ife. So he ran quickly to University of Ife, struck a deal with them. The University of Ife gave us, all of us, admission, but on one condition: we had to write the exams again. So I ended up writing 2 final exams, one for the University of Ilorin, which was cancelled, and then the other one for the university, the Obafemi Awolowo University, as it was then called.
And the venue was still in Ilorin?
Still in Ilorin. And so I graduated from Obafemi Awolowo University without actually
stepping foot
or going to, well, I'd been there, but not as a student. I cut my legal teeth with Akin Delano and Co. in Ibadan. I was a copper then. Chief Delano later ended up to be a senior advocate. Then I started to work with Professor Ebe Kasumu. I worked with Professor Ebe Kasumu for 5 years before I then joined the partnership, Eli Adeniji in Apapa. From Eli Adeniji, I then, in I think July, 1st of July 1999, I set up my own firm, MJ Onigbanjo and Co., which I still work in till today.
Now, let's go back to those formative years, especially, but I just want to know at the point, specifically when you knew you could be parental influence, but the point where you just knew this is it, law is it for me.
My first connection or contact with the legal profession came through my father's, my friend's father. Tunde Kasumu was a good friend. His father was a renowned lawyer. And that was where I bit the bug. And then in my JAM exams, I put in law, and University of Ilorin admitted me. So that was really when I started to.
Right. Well, and how many of your colleagues during that period, Uni Ilorin, University of Ife, how many, what names can you, comes to memory at this time, friends that, have been with you up until this time, who share these experiences you've had?
Well, there are quite a number of them from Ilorin. I think in my set, I think we have about 3 or 4 other senior advocates. Olatoke, SAN is one of them. Sheni Ibiwoye, SAN is another one from my set. We also have judges from my set. And we also have professors and name it. It's been a fulfilling journey.
Right.
There have been ups, as you would expect. There have been downs. I've won cases, I've lost cases. In litigation, with all sense of modesty, I think I've seen a bit of litigation in Nigeria. I've practiced through the length and breadth of this country, in the north and the east, and of course in Lagos, where I'm based. And I have no regrets. If I would be asked, would I do this again? Certainly I would.
Interesting.
Yes.
And of course we know law has many fields, the practice indeed has many fields, but which particular field of law tickles you the most? You're not a stand for nothing, apparently.
Yeah, I mean, my area of specialty, which interests me the most, is commercial litigation. You know, there's nothing like unraveling a very complex dispute and marshalling your client's position in such a way that the court appreciates it and rules in their favor. You know, when that happens, the feeling really is fantastic. You know, it's fulfilling. One feels that one has contributed an added value to the client's business and help them in really resolving something that maybe otherwise would have been a great obstacle for them.
And was it through commercial practice that you were able to earn the SAN title?
Well, largely through commercial practice, but generally because of advocacy before courts, be it in family matters, maritime, largely for advocacy.
Takes us also to your musing, so to speak, on the legal profession. How well has this noble profession fared?
Well, you know, the legal profession has had its knocks, because really nothing sells like bad news. So any time that there's a negative issue, it impacts more on the impression that people have about the profession. But by and large, the profession is doing what it was set out to do. It's resolving disputes, it's putting matters to rest, it's giving judgment, it's also convicting people who run far, who go against provisions of the law. So, to a large extent, the legal profession has done very well for itself, especially in Nigeria. We have a very rich history. You know, we've had some world-renowned legal minds, the Eliases, Gani Fawemi, Chief Williams, Chief F.R.A. Williams. So many people who anywhere in the world would still be giants in the profession. We have some of the greatest advocates you can think of, some of the sharpest legal minds in Nigeria.
All right. We might have to just go back a bit now for specifics on the highs and lows of your journey so far.
I will not want to pick out any particular moment. Other than that, you know, there's some cases, I've done some cases, appeared before some judges, and win or lose, you know, I went back fulfilled that yes, I put in my best, and the decision was, you know, in the circumstances, I accepted it. There have also been times when I believed that the decision ought not to have gone that way. But I also accepted it and filed appeals where necessary. I strongly believe, I don't believe in this trend of where you have a lot of people, when they lose matters, they tend to resort to petitions, calling the judges names, even though they don't have any concrete evidence to back this up. Right. So I think we are gradually, you know, becoming bad losers You know, that spirit that if you lose, if you lose the case, it doesn't necessarily mean that the judge was influenced to do so. I think we need to imbibe that, and you know, if you lose a case, appeal.
If you must.
If you must appeal, and only where it is clear and you have the evidence should one accuse the judge of being influenced. That is what, to my mind, you know, is unpalatable. You know, the attack which the judges are about to, in some cases too, you know, there have been some judges, of course, who have not been fair, but generally you see that our colleagues these days, when they lose a matter, then the next thing is to petition against the judge.
Right. Moyosori Onigbanjo, Senior Advocate of Nigeria, we appreciate your time with us on Legal Focus, the advocate this week. Thank you very much, sir.
Thank you.
We'll be discussing indiscriminate searches of persons by law enforcement agencies. You may ask the question, can the police search me on the road? Can the police enter into my house or premises and conduct search? What is required under what circumstance can this be done? These are some of the questions we intend to answer this week. Now, it is correct to say that the Nigerian police, for example, have the statutory power under Section 4 of the Police Act and also under Section 28 of the Police Act to conduct search on persons who are suspects or suspected of commission of an offense. When this is done, it is said that the police conducted search on the person. Search can be conducted either on the body of a suspect, at the residence of a suspect, or even sometimes on the road, including on the vehicle of someone that is suspected of having committed an offense. What does the law say? By virtue of Section 143, 144 of the Administration of Criminal Justice Act of 2015, the police and other law enforcement agencies have the statutory power to conduct search at the residence of persons and also on the body of suspects who are believed to have committed an offense. For this to happen, there are circumstances in which the police may have to obtain warrants from a court or justice of peace to be able to conduct search. The police requires warrants ordinarily to gain access into the premises of somebody that is being sought after on allegation of commission of an offense. Can the police search the phone of Nigerians on the road? The answer is no, because except the police is suspecting someone of committing a cybercrime or is suspecting that the phone has been used for the commission of an offense. But even at that, the law requires under Section 45 of the Cybercrimes Act, the Cybercrime Prohibition Act of 2015, the police has to obtain a warrant from a court to authorize them to search the phone of citizens. The police does not have unilateral power to begin to conduct search on the phone of persons. I must also say that stop and search, as it is called, is not just that a simple matter, whereby the police can just stop any vehicle and begin to conduct search. On the contrary, the police will require the warrant of the court to be able to do so. However, where reasonable suspicion is established that there is an article in a vehicle, by article I mean a property or an item inside a car or a vehicle on the road, the police may be required, the police may be allowed to have access or request access to conduct search. The bottom line is that reasonable suspicion has to be established. The reason should not be flimsy, should not be arbitrary, it has to be one that can be justified in law. What we have said so far today is that while the law recognizes the power of the police and other law enforcement agencies to conduct search, there is a procedure under the law for that to be done. And of course, there are remedies available to people whose right to privacy, for example, under section 37 of the Constitution, has been infringed upon. Because under that section, the privacy of citizens, their home, correspondence, telephone, and telegraphic communication is protected and guaranteed under that section. Where this right is infringed upon by the police in the course of search, an action can lie in fundamental right enforcement against the law enforcement agency. So I hope that with this, we have been able to clarify what the law says regarding indiscriminate search by law enforcement agencies.
The Supreme Court has dismissed the 4 appeals filed by Senator Ademola Adeleke, who was the candidate of the People's Democratic Party in the last governorship elections in Osun State. The court upheld the judgment delivered by the Court of Appeal, confirming Governor Adegboyega Oyetola as the duly elected governor of the state. The Federal High Court in Lagos has ordered the interim forfeiture of several pieces of jewelry and a customized gold iPhone valued at $40 million belonging to the former Minister of Petroleum Resources, Desiani Alison Madueke. The judge ordered that the 2,149 items be temporarily forfeited to the federal government. Counsel for the Economic and Financial Crimes Commission, Rotimi Oyedepo, had approached the court earlier to argue his ex parte application. The AFCC said it found and recovered the property on the premises of the respondent and that it reasonably suspected that the former minister acquired them with proceeds of unlawful activities. Justice Oweibo granted the order of interim forfeiture of the items and instructed the anti-graft agency to publish the forfeiture order in a national newspaper. The judge adjourned till August 23, 2019 for further proceedings. The Federal High Court in Lagos has granted the final forfeiture of billions of naira and millions of dollars traced to former First Lady, Mrs. Patience Jonathan. The judge also ordered the forfeiture of the huge sums to the federal government on the grounds that they were proceeds of crime. Mrs. Jonathan and the other co-accused had been unable to legitimately account for the ownership of the funds.
And that's Legal Focus on TVC News. Thank you so much for watching. See you again next time. I am Kemi Foladeyemo. Bye-bye.